everyone. We'll be beginning now.
Before beginning any event, we offer our prayers to Ma Saraswati, the goddess of wisdom, and light a lamp to help illuminate our path forward. I now invite our chief guest, retired Justice Sujata Manohar ma'am, and our principal, Dr. Srimati Asmita Vaidya, along with our panelists for the day, to light the lamp and provide us with an auspicious start to the event. I now invite our principal and our event president, as well as the chief guest of the event, to join us on the stage.
Every institution guided to greater heights by those at its helm. At GLC, we owe a debt of gratitude to our principal, Dr. Asmita Vaidya, for the same. She has provided us with her able leadership and decades of experience. In the span of her career, she has authored 8 reference books, 40 research articles, and more than 100 articles on women's rights, which have been published in various national and international newspapers and journals.
She has also been the recipient of several awards, such as the Tejaswini Award, Nation Builder Award, Navdurga Award, Superwomen 2020 Award, and the Best Teacher Award for 2020. With this, we would now like to invite our esteemed principal, Dr. Asmita Vaidya ma'am, to say a few words and provide us with an inaugural address.
Ma Saraswati Namandan. Today's chief guest, Honorable Sujata Manohar Madam, former Justice. The speakers, respected Mr. Alok Prasanna from Vidhi, Advocate Sanjoy Ghose, the Senior Advocate, Delhi High Court, Dr. Suresh Mane sir, former HOD of Law, Mumbai University, Advocate Sanjay Hegde ji, the Senior Advocate, Supreme Court, and Advocate Shekhar Naphade, the Senior Advocate, Supreme Court, the Moderator Kishu Daswani sir, all other professors who are present here, and my dear student friends. A very warm good evening to all. It looks that The galaxy of Supreme Court advocates is here, along with the academicians, to discuss on independence of judiciary, the collegium in question. Madam, at this point of start of the program, I would like to highlight on Government Law College, Mumbai. GLC is arranging these kinds of programs, the academic activities, day out and day in. And we are always lucky to have eminent judges and senior lawyers with us to guide our students. Sir, I am very happy to communicate you that in the academic year 21-22, we arranged 100 different academic programs, out of which 75 were absolutely based on Indian Constitution, and Dr. Mane, he was the part of that function. Not only that, but from this academic year, that is from 22-23, we have started postgraduate program, the research program, and research center of law, that is PhD cell, for enhancing the scope of legal study in an in-depth study of law. At this point of time, we are running 7 certificate courses, out of which 5 were designed by our staff, 2 postgraduate diploma courses, and thus has made the choices available to the students for their studies. I am very happy that you all expertise are here to guide us today. As we all know, collegium is the system of appointment and transfer of judges that has evolved through judgments of the Supreme Court and not by an act of Parliament or by a provision of the Constitution. In March 2021, the Supreme Court asked the government to clarify the status of 55 recommendations made by the collegium for judicial appointments of the High Courts. The Honorable Supreme Court has been repetitively conveying to the government its growing concern about the judicial vacancies in the High Court. And we always talk about the vacancies and reformations in the appointment and the process of appointment. And these recommendations are still pending. Basically, collegium system is legally valid system of appointment and transfer of judges in the Supreme Court and all high courts. The names are decided by the forum of the Chief Justice of India and 4 senior most judges of the Supreme Court. There is no mention of collegium either in the original Constitution of India or in successive amendments. The recommendations of the collegium are binding on the central government if the collegium sends the name of the judges or the lawyers to the government for the second term. But a time limit is not fixed for the government to give assent to the names. This is the reason that appointment of the judges takes a long time. Therefore, there is always a question regarding collegium system. Today, I hope the Supreme Court judges can clarify on collegium system and independence of judiciary, which is the primary characteristic of our constitution. I welcome you all for this panel discussion. Thank you very much.
Thank you, Matthew, for those wonderful words. And I am glad to say that we have had this edition after 3 years of a hiatus of the policy debate because we were not able to conduct this event because of COVID for 3 years now. The Government Law College was established in the year 1855 and has the distinction of being the oldest law college in Asia and enjoys a preeminent reputation for excellence in the field of legal education. GLC, which has a rich heritage and pedigree, has had sterling alumni ranging from Dr. Ambedkar, Mr. Nani Palkhiwala, Mr. M.C. Sethavlal, among others. The students of GLC have distinguished themselves at the bar, the judiciary, and the academia. GLC has been a nurturing ground of 6 of the Chief Justices of the Supreme Court of India, Ms. Pratibha Patil, the former President of India, and numerous senior counsels and legal practitioners. Our institution has been a nurturing ground for the debate and discussion about legal topics for more than a century now. Debating and Literary Society of Government Law College, fondly known as Devlet SOC, is a committee which strives to promote the culture of debate and deliberation. In order to further its agenda, we conduct 2 events throughout the year, and one of which is the policy debate. The policy debate started in the year 2015 at the steps of the Asiatic Library, and today we are at the 7th edition. As mentioned before, we are doing this event after the hiatus of 3 years. The topic for today's discussion is independence of judiciary, the collegium in question. The collegium system has evolved as a result of the first, second, and the third judge's case, and firmly entrenched by the quashing of the NJAC by the apex court. The collegium system is of great importance as it appoints the judges to the constitutional courts, which act as the guardians of the fundamental rights for the common man of the country. Of late, disagreements between the executive and the judiciary have blown into the public discourse and thereby transforming the debate into one having pan-India significance. Today, we will witness a thorough analysis of several topics associated with the collegium, the questions related to the transparency in the system, the lack of diversity in judicial appointments, the judicial independence, and potential reforms in the collegium. This event would not have been possible without the support of Vidhi. We thank Vidhi Center for Legal Policy, a premium legal and policy think tank which acts as the title sponsor for the 7th policy debate. Vidhi's aim involves doing legal research to make better laws and improve governance for the public good. Vidhi's goal and work makes it the perfect partner for the 7th policy debate. I would now like to invite Ms. Janali Dani from Vidhi, Maharashtra to say a few words.
Thanks, Shrishti. Good evening and welcome everyone. I am Janali Dani, a senior resident fellow leading the Bombay team of the Vidhi Center for Legal Policy. Some of you may already be familiar, some of you already know about Vidhi and would be familiar with Vidhi's work. Vidhi is an independent think tank, like Shrishti said, based out of Delhi, Bangalore and now Mumbai. We conduct legal research to make better laws and improve governance for the public good. We do this by engaging with the Government of India, state governments, the judiciary and other public institutions as well as civil society members. Our projects have involved undertaking original legal research, petitioning courts on important law and policy issues, and collaborating with civil society and academic institutions as well as other stakeholders to positively impact law and policy making and consequently governance. Some of Vidhi's projects over the last few years have involved, for example, assisting the E-Committee of the Supreme Court to develop the vision for Phase 3 of the E-Courts project, assisting the Bankruptcy Law Reform Committee of the Government of India on the design, drafting and implementation of the Insolvency and Bankruptcy Code, and intervening in the Supreme Court petition which eventually led to the 2018 judgment legalizing assisted medical directives and which facilitated the right to die with dignity. Vidhi's Maharashtra team, based out of Mumbai, was set up in 2020, right before the pandemic. Its projects in the last 3 years have focused on devising systemic solutions to improve the plight of orphans and abandoned children in Maharashtra during COVID-19, reforming the regulatory framework for public libraries in the state, and reviewing and suggesting reforms to the regulatory framework for transport. Aside from improving law and policy, making through our research, Vidhi has also been actively interested in shaping the next generation of lawyers and inspiring them to explore a career in public policy. For this purpose, we have set up student initiatives called Kautilya Societies in 9 universities across the country. As a part of these societies, students have undertaken legal research, hosted discussions and events on relevant legal policy developments, collaborated on events with Vidhi, written for the Vidhi blog, as well as launched their own blogs, newsletters, and podcasts. Vidhi's collaboration today with the Government Law College on the 7th edition of the policy debate has also stemmed from a similar space. The aim was to increase public and specifically student awareness on legal and policy issues of contemporary significance. And on that front, I think the chosen topic today for the debate is highly appropriate. The Debating and the Literary Society could not have picked a better topic. Without further delay, I think it's now time to set the stage for the debate. And for this, I would first like to introduce our esteemed chief guest, retired Justice Sujata Manohar, who would be giving the opening address for the debate. Justice Manohar, we're very honored to have you here actually, has served the Supreme Court of India, the Bombay and the Kerala High Courts. She holds the distinction of being not just the first woman to be elevated as a judge of the Bombay High Court, but also the first woman Chief Justice of the Bombay and the Kerala High Courts. She was appointed as judge of the Supreme Court in 1994 and she retired in 1999. A student of the Elphinstone College and Lady Margaret Hall at the University of Oxford, ma'am started her career as an advocate of the Bombay High Court before being called to the bar at Lincoln's Inn. In her early years, ma'am primarily dealt with commercial matters before moving to take up several pro bono and public interest matters. During her decades-long career, both as an advocate as well as a judge, ma'am has made significant contributions to the Indian legal system, particularly in the areas of human rights and gender justice. Ma'am was incidentally also on the bench that pronounced the judgment in the third judge's case in 1998. She has been a former member of the National Human Rights Commission, served as a chairperson of the Board of Visitors at the Judicial Officers Training Institute in Nagpur, and has worked as a chairperson of the Bombay High Court Committee of Judges, which was formed to set up family courts in Maharashtra. Ma'am has won many awards over the years, her latest being the Ruth Bader Ginsburg Medal of Honor by the World Jurist Association. This award is granted to women jurists who fight to defend and strengthen the rule of law and consolidate society's advances in gender equity. Ma'am, it is our great honor to welcome you here today. I'll leave the floor to you for your opening address.
The principal of Government Law College, Dr. Vaidya, my panel members, Vidhi Center, professors of the college and students. Let me begin by congratulating the Government Law College and the Vidhi Center for organizing this panel discussion with such distinguished speakers before you. It will give you an object lesson in how constitutional principles and constitutional provisions apply in real life situations. Let us look at the issue of independence of the judiciary. From a constitutional point of view, keeping politics out of consideration, let us look at it as lawyers. We are fortunate to have a constitution which has stood by the country for almost the last 75 years. Schedule 3 to the Constitution prescribes the oath of office of a judge. You must have read it. He or she has to take an oath to administer justice without fear or favor, affection or ill will, and in accordance with the Constitution and the laws. In a nation which believes in the rule of law, there is an implied presumption that the laws will be fair and just. Judges are expected to act impartially without succumbing to threats or without being tempted by rewards, unaffected by prejudices or favoritism, and decide in accordance with law and the Constitution. This implies integrity and independence of the judiciary. In a constitution which provides checks and balances while dividing power among different organs of governance, judiciary therefore has a crucial role to play in keeping this balance. Its independence and integrity are of utmost importance if the constitution has to work properly. Now, a country which hopes to be and intends to be governed by the rule of law requires this kind of an independent judiciary. And independence is also necessary to protect human rights from attacks by the powerful. The problem is, how does one ensure the judges who are appointed possess such independence and integrity? Article 124 of our Constitution, as you know, as students of law you must have studied, requires the judges of the Supreme Court are appointed by the President after consultation with such of the judges of the Supreme Court and the High Courts as the President deems necessary, but the Chief Justice of the Supreme Court shall always be consulted. In actual practice, in the past, the recommendation of the Chief Justice of India was always accepted. And ordinarily, the senior-most judge of the Supreme Court would be appointed as the Chief Justice of the Supreme Court of India. Now, when both these conventions began to be ignored by the executive, on whose recommendation judges and the Chief Justice of India were appointed, when these recommendations, because ultimately the President acts on the recommendation of the executive, so when these conventions were slowly being ignored, we had the decision in the second judge's case in the Supreme Court Advocates on Record Association versus the Union of India in 1993, where it was held that the opinion of the Chief Justice of India was binding, and his opinion was not his individual opinion, but was arrived at in consultation with the next two senior-most judges of the Supreme Court. Now, I am not going into other details laid down in this judgment, since you are all very familiar with these. If the executive had an objection to the recommendation, the name could be sent back to the collegium. But if the name was reiterated, it would be binding on the executive. The presidential reference in 1998 expanded the collegium to the next four senior-most judges. It should be noted that there is no prohibition against consulting others. If the Chief Justice or the collegium so desires, there are equivalent provisions for High Court judges. I am not going through the details because I am sure you are all very familiar with it, or at least you must have read the judges' cases before coming here. What we have to consider is this current system of appointment adequate to ensure appointments, first of all, of judges of the requisite caliber, required to interpret and apply properly the Constitution, and whether it ensures appointment of judges who possess independence and integrity, which is the subject of our today's discussion. Now, much has been said about the defects in the collegium system, and much criticism is levied on the system on the ground that judges appoint judges. In 2021, a round table was organized by Justice K.T. Desai Memorial Committee on Judiciary, its independence and integrity. There was an international panel looking inter alia at the method of appointment of judges in different countries. This panel included our Justice B.N. Sri Krishna, Justice Mary Arden, Judge of the Supreme Court of UK, Justice Albie Sachs of the Constitutional Court of South Africa, former judge, Mr. Sharad Rao, Senior Advocate of Kenya, who was the chairman of the Judges and Magistrates Vetting Board of Kenya, a constitutional post. Then Mr. Arvind Datar, our senior advocate, and Dr. Jan Mansell Smith of the Bingham Center for the Rule of Law in London. Mr. Arvind Datar referred to the case in which he appeared with Mr. Fali Nariman, which struck down the 1999 amendment regarding National Judicial Appointment Commission. He pointed out that the amendment had to be struck down basically because the amendment was badly drafted and the proposed commission had a majority of non-judicial or executive members. In this matter, Mr. Datar said that they had conducted a survey of the constitutions of 193 countries, and it was found that purely judicial commissions existed in 60 of the 193 countries. In other countries where there was a judicial commission mixed with some other models like a multi-layer consultation, some role of the executive and so on, such a judicial commission existed in 103 countries. In 57 of these 103 countries, lay persons were included in the judicial commission, but not in all. There is nothing per se wrong in having a judicial appointment commission if it is properly constituted. It's a big if. What we have to consider is who are the people best able to find out persons who can be appointed as judges, who in addition to being well versed in law are also independent and have integrity. Or in the case of Supreme Court, which of the judges functioning in the High Court have these qualities? I think the answer is obvious. Those not involved in the functioning of the legal system may not always be aware of the caliber of existing judges who may be suitable to be appointed to the Supreme Court, or lawyers who are suitable to be appointed as High Court judges. Executive viewpoint, of course, has to be considered. The executive may have access to material which the judges may not have, but the executive, in my view, cannot have the final voice in appointment. They are today litigants in a large number of matters, including matters involving human rights. Of course, preservation and protection of human rights is the responsibility of all organs of governance. But when a petition comes before a court seeking protection of human rights or challenging violations of human rights, more often than not, the other organs of governance are, I'm afraid, the respondents and not always private parties. Justice Venkatacharya had proposed a judicial appointments commission which had a clear majority of judicial members but had some members of the executive or other eminent lay persons. The other alternative is to remove some of the existing problems with the collegium system and provide a proper administrative setup for the collegium to collect data regarding the performance of existing judges and lawyers, which can help the collegium in deciding suitability of a candidate for judgeship in the High Court or the Supreme Court, as the case may be. It should also be possible to have an informal consultative group which can be specified to be consulted by the collegium before it makes its decision. Every country has its own variation about the appointing body. We should have one which is best suited to us and which is best suited to uphold the principles of competence, independence, and integrity. Then I would like to end with by reading the conclusion of the Justice K.T. Desai round table. I will read the relevant parts of it. It starts by saying, whereas judicial independence and integrity are prerequisites for the rule of law, and a constitutional democracy which provides checks and balances between different organs of governance depends on the judiciary for the proper functioning of different organs of governance in accordance with the Constitution and for proper enforcement of laws. And whereas a competent, independent, and impartial judiciary is essential for the protection of human rights, and whereas it is essential that judges individually and collectively discharge their duties without being influenced or pressurized in any manner, and generate, maintain, and enhance public confidence in the judicial system, and whereas to have and to maintain a judiciary with independence and integrity, it is necessary that persons appointed as judges have the requisite independence and integrity and hold office so long as they possess these qualities. It is hereby declared as follows. I will read the portions in the system of appointment of judges in different countries. There is a need for a judicial appointment system which is capable of resisting populist or political demands and is strong enough to withstand pressures which prevent appointment of independent judges. A judicial appointments commission or a judicial services commission, where it exists for selecting candidates for appointment, should include some lay people from diverse non-political backgrounds as also members of the executive, and where this is acceptable to the judiciary, from the legislature also, as well as eminent lawyers, jurists, judges present or past. But the final say in the appointment of judges should be of the judiciary, which will consider the views of the other members of the selection committee before making a final selection of candidates. Where only a judicial body selects suitable candidates is at present. Actually, it is not correct to say that only the judicial body selects, because the collegium does consult a large number of people. The selection should be made after consulting the executive and some other appropriate persons, such as eminent lawyers and jurists, or retired judges and eminent lay people from other fields. While keeping the above, I am not reading about the provisions relating to removal of judges who are not up to the mark. While keeping the above principles in mind, nations should evolve an adequate system of appointment and removal of judges which ensures that the nation has a judiciary which has and is seen to have independence and integrity. Well, I look forward to seeing what the panel has to say on this subject. A lot of the things have been said one way or the other in the newspapers and in the media, and I think you will all benefit by listening to what they have to say and make your own decisions as to what is appropriate for our country. Thank you.
Thank you, ma'am, for that wonderful speech. It was truly an incredible opportunity for our students to learn from your inspiring words. Without any further ado, I would now like to invite our principal, Srimati Asmita Vaidya Madam, to felicitate our chief guest for the day. I would now like to invite our professor in charge, Dr. Shweta Shiraskar ma'am, to felicitate our event president and principal, Dr. Srimati Asmita Vaidya Madam.
Without further ado, we present to you our esteemed panelists for today. Our first panelist is Senior Advocate Shekhar Naphade. Mr. Naphade is a prominent senior advocate with over 4 decades of experience in legal profession. He is an alumnus of GLC, and we are grateful to have him back here. He has appeared in several landmark cases like the Aruna Shanbag case, anti-Sikh riots case, and the recent Sabrimala temple case. He has also been a member of the Law Commission of India and he has made significant contributions to the development of Indian law. Mr. Naphade was also involved in the case of Justice Sen's removal from the Calcutta High Court, one of the only incidents of a judge's removal being initiated in the history of India. We would now like to call upon Mr. Naphade on the panel. Yes.
Our second panelist for the day is Senior Advocate Mr. Sanjay Hegde. He is a senior advocate at the Supreme Court of India. Of late, he represented several people who were declared as foreigners in the NRC cases, and also for the citizens of Mumbai in the Ari Forest case. He was also appointed as an interlocutor by the Supreme Court to talk to the protesters at the Shaheen Bagh protest. He is a passionate advocate of civil rights, which makes his views all the more important for us to understand the impact of the collegium system on the general public and their civil rights. We now like to invite Sir to join the panel on stage.
Our third panelist for today is Senior Advocate Sanjoy Ghose. Mr. Sanjoy Ghose is Senior Advocate of Delhi High Court and has been a standing counsel of Delhi High Court and additional standing counsel for the Delhi government. Unafraid to voice his opinions, Sir has been a voice to be reckoned with on platforms such as Twitter. In his various blogs and articles on collegium, he has called attention to the transparency and accountability mechanisms in the collegium system. So now we welcome you to the panel.
Our fourth panelist for the day is Mr. Alok Prasanna. He is co-founder of the Vidhi Center for Legal Policy and the lead of Vidhi Karnataka. His areas of research include judicial reforms and constitutional law, which provide him with an admirable degree of understanding and expertise on the topic at hand. He writes a monthly column for the EPW and has been published in the Indian Journal of Constitutional Law as well as the NLS Review. Apart from media outlets such as the Hindu, Indian Express, the Scroll, the Quint, and the Caravan. We'd now like to invite Sir to join us on stage.
A fifth panelist for today is Dr. Advocate Suresh Mane. Dr. Advocate Suresh Mane is a former professor and head of Department of Law, Mumbai University. Having more than 30 years of experience in teaching law and guiding students, he was the winner of the Best Law Teacher Award of Mumbai University in 2010. He has held key positions like the president of the Mumbai Port Trust and was the founder president of the Bahujan Municipal Kamgar Union. Mr. Mane has written over 10 books, several monographs, and over 60 articles which have been published in national and international magazines and journals. He is one of the most renowned voices for the rights of Bahujan Samaj, highlighting their concerns of representation and the need for greater diversity in the collegium. So we now invite you on stage.
Lastly, we invite our moderator, Professor Kishu Daswani, to the stage. Professor Kishu Daswani has been a professor of law at the Government Law College for over 30 years. He has also been a professor of international and humanitarian law at the Rotary Peace and Conflict Resolution Center at the Chulalongkorn University of Bangkok and Thailand. He has conducted over 50 workshops in peace and conflict resolution in colleges with Indian as well as international students. He is also a visiting professor at the Naval War College of Goa. We'd now like to invite Sir on stage to initiate the debate. Thank you very much.
Honorable Justice Manohar, my principal, Dr. Sujata Manohar, my panelists, friends. Ma'am, you stole my thunder. I had prepared this entire introduction about the collegium, but that was wonderful. I mean, you did it way better than what I could. And Of course, in a way, let me tell you a story. Yes, I take the inspiration of this name from Who Moved My Cheese, written by Stephen Johnson. The story I'm going to tell you is Who Moved My Constitution, written by a parliamentarian. See, so when we really start way back in the constitutional debates, you have this discussion about who's going to appoint the judiciary or members of the judges across high courts and supreme courts. And Article 124 comes up that the president will appoint in consultation with the Chief Justice. The word was consultation. A debate was whether it should be concurrence, and Dr. B.R. Ambedkar said, no, it has to be consultation. Not only are the three arms of the government separate, but there have to be checks and balances. Now, the Constitution came out, Article 124 was in place, and for the first several years, and probably I would say till 1967, there was this lovely live-in relationship between the executive and the judiciary, because the judiciary said, thou can amend the fundamental rights. See, Shankari Prasad and Sajjan Singh from 1951, 1964, and as long as the government could amend the fundamental rights, they had no problem with the judiciary. So from 1951 till 1967, and 67 saw two landmark incidents. One was Golaknath, where it said that thou cannot amend the fundamental rights, and also the advent of a lady called Indira Gandhi. See? And she had a lot of economic and social reforms to make, and given that land acquisition could not be done because your fundamental rights couldn't be amended, you had the first clash with the judiciary. And post Golaknath, I believe, and maybe Mr. Prasanna can tell us more, between 71 and 72, in a period of 15 months, 9 judges were appointed in consultation, inverted commas, with the Chief Justice by the government, hoping that a judgment would come that would take care of the 24th, 25th, and 29th Amendment. And I don't need to tell all the law students here, we had Keshavanand Bharati versus State of Kerala. And I do believe that that judgment is so critical for you and me to sit here and even have this debate today. Because that judgment has influenced the 1981 judgment, the 1992 judgment, and the NJAC. And in Keshavanand Bharati, the judiciary told the executive, thou can amend the fundamental rights, thou can amend any part of the constitution, except don't touch the basic structure. And the executive says, what is the basic structure? The judiciary says, we will tell you what the basic structure is. We will keep it amorphous, we will keep changing, we'll keep magnifying it, we'll keep reducing it. So over a period of time, a government that wants to enforce its policy, a government that, as our current law minister said, who's answerable to the electorate, needs to make changes. And the biggest stumbling block in that is not the opposition. Ladies and gentlemen, it's hardly there in this country today. It's not the media. I don't have to tell you. The only stumbling block to a majoritarian government is a counter-majoritarian judiciary. And the topic of today's debate is the independence of this judiciary. Over a period of time, going into 1992, not only the judiciary hijacked the constitution, they just hijacked it. They said, we will tell you what the basic structure is. In 1992, they locked it away. They said, you cannot even tell us what about the Constitution. You cannot even select who's going to decide on the Constitution. So, I'm reaching out to students here, probably their first year students here, to get a sense of where this debate has started. And some of you have probably been born after 1992, in an era of a collegium system, in an era of an independent judiciary, in an era of easily the most powerful judicial body in the world that selects itself, that decides what the Constitution can do. We must legitimately ask that, is this too much power? We must legitimately ask that, is the parliament or the government entitled to question this power? We should legitimately ask that, are the people in the judiciary the right people for the job? And in a self-propagating collegial system, can there be certain bad apples that can lead to a bad harvest? Now, these questions I hope the panel will address today and much more. And I was asked a question here, before by Mr. Naphade. He said, "Do you want it hot or do you want it cold?" So, who my panelists are here and all my lovely friends here, I am sure all of you firmly believe in the rule of law. Yes. I'm sure none of you will do anything that is breach of privilege, sir. I'm sure none of you will do anything that is contempt, sir. But having said that, this is an academic institution. An institution that has been associated with the likes of Dr. Babasaheb Ambedkar, Lokmanya Tilak, Justice M.C. Chagla. This academic institution, sirs, has a unique academic license. So please, go ahead and let your speech be free and let your comments be fair. This is not I was just giving a very serious talk right now about Babasaheb Ambedkar and Tilak and about free and fair speech. And I was going to conclude by saying that this is or could be an existential crisis for our democracy. This entire thing could actually question the sanity of our constitution. So as Confucius said, may you live in interesting times. These are interesting times. And I will call on the members of the panel to speak. And now, before I conclude, let me tell you an interesting story about Mr. Ghose here. You want to tell that? Yeah, okay. So here my version of it. He decided to look for famous alumni of Government Law College. And while hunting for famous alumni, I do not know why he selected a particular gender. And I don't need to tell you, guess who showed up on his Instagram, right? So, yeah, on Google, yes, who showed up. So I look forward to an interesting discussion and debate. Can I ask Mr. Naphade to please open the proceedings? Thank you.
Honorable President Sujata Manohar, Principal of the college, Professor Daswani and my young students. Happy to see that so many of you are interested in this debate. I do not subscribe to the view that independence of the judiciary can be ensured only if the judges appoint judges. The third proposition which I make, which may also startle you, that independence of the judiciary, to put it in the language of calculus, is a function of a political process that operates in the world polity. What do I mean by this? What I mean is this, that we have three wings: the judiciary, the legislature and the executive. If the executive is powerful, then a political executive which occupies the office for the time being and is backed by a substantial majority in the parliament, you will always find that the judiciary is always on the back foot. And I demonstrate this. First, go back to 1951, the first amendment to the Constitution. According to me, the first amendment to the Constitution has caused a serious damage to the constitutional culture. The judiciary conceded to the parliament an unlimited power to amend the Constitution. It was held to be a constituent power. We are still not sure whether it's a constituent power or otherwise. Why it happened? Because the political executive in power had a massive majority in the parliament. The towering personality of Pandit Ji. Now, the second illustration which I give you is 1967. We have Golaknath case. The Golaknath case went exactly to the other end. Why this happened? Because the political executive was not powerful. The party in power had a wafer-thin majority. Therefore, the judiciary ceased to be on the back foot. I can give several illustrations from the recent contemporary history that whenever there is a powerful political executive in office, backed by a massive majority in parliament, the judiciary will always be on the back foot. Now I come to the main point. SP Gupta, the second judge's case, the third judge's case, with due respect to Sujata Manohar ji, it's a constitutional coup. Why do I say that it's a constitutional coup? Independence of the judiciary is a part of basic structure. There can't be debate about that. But the method of appointing is not part of the basic structure. If you look at the constitutional scheme, appointment of judges is purely an executive and an administrative function. All that the Constitution provides, Article 124 or Article 217, that the President shall in consultation with the Chief Justice. Now, as a result of these three judgments, from consultation we have gone to concurrence, and from concurrence now we have gone to the collegium being the appointing authority virtually. This was never contemplated by the framers of the Constitution. In fact, Article 124 and 217 have been turned upside down. If you concede, if you accept that making appointments to judicial office is an executive function, it can't be legislative, it can't be judicial, there can't be a debate that it's purely an executive function. If it is purely an executive function, how does judiciary take it over? That is why I have described it as a constitutional coup. Now, come to the Supreme Court striking down the National Judicial Commission. I don't want to go into the details of its composition. That will take a lot of time. But what is this we the people of India? The Constitution, the preamble begins with we the people of India. I was not there when the Constitution was on the unveil, except Justice Sujata Manohar, none of us were there. Now this we the people of India means who? The people who framed the Constitution in 1950? Now, are we not we the people? Can we not have a relook at the Constitution? Have we permanently surrendered our political sovereignty? The answer is no. Therefore, subject to the basic structure doctrine, we the people, we have a right to change the Constitution. And I personally consider the judgment of the Supreme Court in Judicial Appointment Commission totally flawed. It's, in fact, according to me, appointment to judicial offices is purely a part of administrative function, and by a judicial coup, it is taken over by judicial body. This, according to me, is contrary to the basic structure. More of it as and when the questions are put to me. Thank you very much for giving me this.
Okay, thank you, Mr. Naphade, for those really interesting words, though I may tend to disagree with you a bit there. Because right now we are faced with a very strong majoritarian government. So do you think the judiciary is going to succumb? Maybe I'll let you answer that when we come to it. And also, during the Keshav Anand Bharati judgment, we did have a very, very strong majoritarian Indira Gandhi government, and the judiciary really stood up to it. So while the sine curve may work at some times, maybe we'll have to question it. But very, very valid point on your NJAC comments on the Supreme Court, whether it was a valid strike down or not. Thank you so much. Mr. Hegde.
Pleasure to be here, and I'm here at last because this very college denied me admission some 30 odd years ago, and I went off to KC. No, but this college then made it up to me. My wife, who I didn't know then, graduated from here, and let me tell you that she is, as Rampol describes Mrs. Rampol, she who must be obeyed. And I do think that government law colleges, if I go by the exemplar of my wife, are very good men and women of law and who can lay down the law. And it was a professor of this law college who aptly described the situation before the collegium came in. It was Ram Jethmalani who in those days, before the collegium, said that there are two kinds of judges. Judges who know the law and judges who know the law minister. And that was the truth. Because, yes, when we had a system where you had consultation with the judges, but no real concurrence. So it didn't really matter if the judges thought you were suitable, but it did matter whether the law minister thought you were suitable. And we had all kinds of law ministers. We've had all kinds of law ministers even now. Some of them have been eminent lawyers. Some of them have eminently avoided the court. But they're all eminent men. A law minister is always an eminent man. God knows what honor, what law minister may give on some people of us out here on the podium someday. But now to return to Mr. Naphade's point of a constitutional coup. Yes, to a certain extent, it was a constitutional coup, saying that, consultation does mean concurrence, and concurrence doesn't mean that you need to seek the concurrence of the Chief Justice of the day. What it means is that you have to take the views of the judiciary as a whole, and that view is represented by the senior-most judges. Unfortunately, I think what they got wrong was a simple question of semantics. The collegium, a very Latin word, which simply meant a guild of associated people. If they had simply said that the judicial committee, the senior judges will recommend, and that recommendation would normally be accepted, and the government will have to have very strong reason to deviate from that recommendation. Then the attack that we see today, making collegium a sinister word. Oh, these are collegium judges. There's a Chacha Bhatija, uncle nephew kind of situation out there. This is a situation where judges appoint judges. No, the collegium has never acted like that, or they never really operated like that. There have been, I'm told about somebody who's a friend of mine, who's a judge and very near a Chief Justice somewhere. But apparently the recommendation of the Chief Justice of the day of that High Court was, I don't know this gentleman, but the Chief Minister of the day assures me that he's an honorable man and a good candidate. So it's not as if political advice was not being taken. It is not as if the executive was entirely sealed off the process and judges were delivered by an immaculate conception in a closed room. Now, the real problem today, and this is what I want the younger people of India to consider. Why is it that we suddenly have an attack on the collegium? Why is it that our highest constitutional functionaries go forth saying the collegium is bad, the basic structure is bad, this and everything concerning the institution of the judiciary is subject to troll attacks, is subject to vicious comment, and also absolutely unregulated, immoderate attack. And the reason is simply this: Mr. Naphade adverted to it. Mr. Naphade adverted to how in times of powerful governments, powerful majorities, the governments think that they are almost supreme. They do not like any system of checks or balances. And what exactly are judges? Judges are there to defend the citizen against despotism. They are there as a brake on despotism. And no despot really likes to be questioned. It is said about the great exemplar of Peshwai justice, Ram Shastri Prabhune, that when Ram Shastri Prabhune went to see the Peshwa, the great Madhav Rao, was busy in austerities. And Ram Shastri Prabhune then went away. He couldn't meet the Peshwa. He comes back the next day and asks the Peshwa, please give me leave to go to Kashi. I want to withdraw from here. The Peshwa asks, why? What has happened? What's wrong with this? So he says, yes, our religion prescribes the austerities. You, as a practicing Hindu, are entitled to do that. But when you are Peshwa, you are supposed to only devote yourself to government service. Leave the Peshwai, come with me, I will teach you every austerity. So this was the kind of gentle reproof, the kind of break on even a variation in good governance that was part of the Indian legal tradition. But no, whether it was Mrs. Gandhi's time, whether it is this time, we do see a certain insolence of office which has taken over the government. And we do not see it only here. Right now, please, it's not being reported on Indian media, but please see what's happening in Israel. If you see, there is a very powerful politician who's come to power finally with a majority, Benjamin Netanyahu, and he wants to appoint judges of his kind. And it is not only the judiciary who's opposing it, it's not only the opposition who's opposing it, but it is the people of Israel themselves who have come out. Look at our neighborhood. When Pervez Musharraf was at the height of his powers as dictator of Pakistan, what was it what was the mistake that got the entire edifice crashing? That was when he sought to replace Chief Justice Iftikhar Chaudhry, and it was a lawyers' movement which brought down Musharraf. The rule of law is worth nothing if the people of the country are not invested in it. As Justice Learned Hand once said, liberty lies in the hearts of men and women, and when it dies there, no court, no constitution can do much to save it. And it is that kind of spirit which any set of rulers really fear. The attacks on the collegium which have happened in recent times are simply this, that this is an institution which does not exactly listen to us, despite two huge majorities. This is an institution which has to be remolded closer to our heart's desire. So at this stage, who would you rather trust? Would you rather trust a collegium or senior judges who have seen everybody perform and whose recommendations the government should normally follow? And that is the law which currently operates. Can there be a better system? I dare say there can be a better one. But for the moment, can there be a safer system? I leave that answer to you. Thank you very much for that.
Okay, thank you, Mr. Hegde. Those are very strong words. You said that the judiciary is necessary to create a break on despotism, and how you can mold the judiciary to support the current government's political ideology in some way as a last standing institution. I think you made very, very valid points there. Also in the context of Israel, and one of the points that, Mr. Hegde made, the entire country of Israel is in revolt. They are standing up and saying, we do not want this passed. I do not see that same thing happening in this country. I do not know, maybe you could comment on that, Mr. Ghose, whether you could see the same thing happening. And before I pass on the mic to you, I welcome the son-in-law of GLC, Mr. Hegde. Please, a round of applause. Mr. Ghose.
Well, at least the GLC can't be accused of nepotism. The collegium is. Okay, I must say this afternoon I was walking down the beautiful road. On the one side was the High Court. And ma'am, you have one of the prettiest High Courts in the whole country. And I was looking at these devils, the gargoyles. And I was looking at the beautiful Maidan. And I was in the road, devil and the Maidan. And it's only when in the evening I called our guru, the Encyclopedia of Bombay in the Supreme Court, Shekhar ji. He said, do you know that there was nothing called the Maidan? It was the deep blue sea. Earlier, the sea used to come till the Maidan, and the High Court was just next to the sea. So then I realized where I am on the collegium issue. The devil and the deep blue sea. So who do I side with? The executive or the judiciary? The devil or the deep blue sea? Who's the devil? Who's the deep blue sea? We leave it, because he said contempt, so we leave it out for the time being. Now, Professor has talked about Ambedkar. And this is the institution of Ambedkar. I'm really, really blessed to be in this, this sacred precincts. You have a galaxy of alumni. Ambedkar also said, sir, and please remember, that the most perfect legal document, the Constitution, he said in the last day or the second last day or the last day of the Constituent Assembly, that the most perfect of document in the hands of an imperfect people will cause ruin, will be useless. So ultimately, as Mr. Hegde has said, it is in the hands of the people. It is in the hearts of you. If you don't value your liberty, if you don't value your rule of law, if you don't value the independence of the judiciary, it doesn't matter. So, Shekhar ji has given you some shocking statements. Let me give you another shocking statement. I hope I will outbeat his shocking statements. And that is that in this country, whether you have the collegium system or pre-collegium system, never has an appointment ever gone through, a judicial appointment has ever gone through without the blessings of the government. So, the executive is always there. It is just that you formalize the bargaining system. Many of us will not be able to openly discuss with you the kind of bargaining between the executive and the judiciary that happens behind the public gaze. You now see a little bit, as we would say, a little few lollipops. You will see some bargaining or some fight happening in the public gaze. the collegium issuing a statement that, how could you not appoint this judge of the Bombay as a judge of the Bombay High Court just because he circulated some article in social media. It will happen in the public gaze, but in the private gaze, you'll have Victoria Gauri appointed to the Madras High Court. So let's understand something very clearly. And the good thing is that we are all talking about this in every city of this country. There was a debate recently on the collegium system in Delhi. And one of my juniors from the National Law School, Bangalore, Aditya Sondi, whose name went for appointment, but he says he went to a function and he talked at a seminar in National Law School and he talked about the CAA and he spoke against the CAA legally, not politically. And that was held against him by the government. The government returned his name. The collegium reiterated it. The government sat on it. As a result, not only it sat on it, it actually appointed judges who were recommended thereafter. So he withdrew his name. Now he said something very important and it left an impression on me. He said, when does the independence of the judiciary come? Does it come the day you're sworn in? Justice Sujata Manohar brilliantly read out the beautiful oath in our constitution, without fear or favor. But when does fear and favor start? Does it start on the day of the oath, when you come dressed in a nice sari or a nice suit? It comes from the bar. It comes from the law school. The law schools are the mother of the bar. And the bar is the mother of the bench. Now, if you are going to write an article as a law student, fiercely criticizing the government. I am not talking political parties, whichever party, NDA, UPA, left, whoever's in power. You as a law student write an article, legal article, scholastic article against the policy of the government. Then you graduate. Then as a lawyer, you write an article against the government or circulate an article against the government or for the government, independently. Now, when you are considering that person to be appointed as a judge, will you hold that against him? Will you say he has been independent, he has written articles against me, so I will not appoint him as a judge, as happened with Aditya Sondi? So then how will you get an independent judge? When does the point of independence come? You want pliant people, you want lawyers, law students who will be fearful, who will be scared, who will not say anything, who will keep quiet, who will not be controversial, and then you will swear them in as judges and you will expect that they will all of a sudden overnight become independent judges? Is it possible? So this is what is happening today. And let's be very clear. Again, as I said, I'm not blaming any political party. That is why I'm between a rock and a hard place. Because I am absolutely opposed to the collegium system. Before the collegium, you had Gajendra Gatkar, you had Krishna Iyer, you had Chinnappa Reddy, you had Kaniyar, you had Vivian Bose. Post-collegium, you have Arun Mishra. You have Gogoi. Very good. I'm not saying anything, I'm just giving the names. You are getting the So what is the collegium system? It is just, you scratch my back, I scratch your back. Where is the voice of the Dalit? Where is the voice of the battered woman? Where is the voice of those who are not people like us? I went to an arbitration and I normally like wearing Indian clothes. If you believe in the arbitration for 5 minutes, the judges who are retired judges of the Supreme Court were discussing why I'm not wearing a coat, why I'm wearing a band gala. So these are the people who will want people like us. So that perpetuates a clique. So you always have the upper caste or upper middle class or the English speaking or one kind of people. And of course, you may make whatever rules, but ultimately when it suits them, rules will be changed. I will give you some of the ludicrous issues of the collegium. The collegium, and I'm giving names. I am one of the, as you know, all of you who follow me on social media, I'm not scared of anyone. The collegium, in its wisdom, refused to elevate Justice Anirudh Bose, his lordship is a judge of the Supreme Court today, as a judge of the Delhi High Court. And the recorded reason was that Delhi High Court is a premier High Court, so he should be sent to Jharkhand. Justice Rajendra Menon was then appointed as a Chief Justice of the Delhi High Court. A few months later, Rajendra Menon was denied elevation to the Supreme Court and Justice Bose was brought to the Supreme Court. So, what are these reasons? What is this logic? What works in the mind of this collegium? And what kind of minutes were made? Most important thing is, and we are grateful to the author. I'm so proud that the author of the judges' case is sitting in front of me, Justice Manohar. And one of the most important things she and our bench did was to say, and that is the actual protection of independence of the judiciary, that once a name is reiterated, it has to be appointed. The government has no say. Now I ask you, when Mr. Satyan, John Satyan's name was reiterated by the collegium, and when the collegium said Victoria Gauri and others will only be appointed after you have appointed this person, the government, what did the government do? The government did not honor the recommendation of the collegium. It did not accept the reiteration of John Satyan, and it went ahead and appointed Victoria Gauri, Justice Victoria Gauri today. Contempt proceedings in Madras, maybe. So, Madurai bench. So what did the Supreme Court, what did the Supreme Court do? What did the collegium do? When a case was filed, now first of all, according to me, this should have been taken up in the administrative side by the Supreme Court. The collegium should have immediately directed that you have not accepted our recommendation and this warrant of appointment is not right. Directed the Chief Justice of the Madras High Court not to swear in these people, and should have directed the reconsideration on the administrative side. If not possible on the judicial side, there should have been a constitutional bench of the 5 senior most judges of the Supreme Court. And contempt proceedings should have been initiated against the central government. But you have not done that. So at the end of the day, if we have to see the power of the Supreme Court, even if you accept this collegium system restored or followed, you will have to ensure that the government respects what you are writing. You are reiterating daily, they just take your recommendation and just say, so what? You keep writing, I'll ignore it. And what do you do about the ignoring? Nothing. And let me end by giving you, and I said, I am not a politician. I don't have any political views because I believe all politicians are the same. When NJSC came, all political parties supported the NJSC amendment in the parliament. They are all the same. They all believe that the judges are overreaching. And this happened not now. It happened from Nehru's time. When Harilal Kania, your alumnus, died, Nehru was opposed to Patanjali Shastri becoming the Chief Justice of the Supreme Court of India. Do you know what the other remaining judges said? They told Mr. Prime Minister, either you have a Supreme Court and you appoint Patanjali Shastri or we all resign. They said we will resign en masse. The same thing happened when Patanjali went and Justice Mahajan had to be appointed. And Mahajan and Nehru had a long history because Mahajan was the Prime Minister of Kashmir and used to fight with Nehru routinely. Sardar Patel had to always, make them sort out, patch up. So again, he said, I don't want Mahajan to be made Chief Justice of India. Again, Vivian Bose and the others said, we will resign. So where is the unity in the court also? I am in a hard place, and I explained why I'm in a hard place, because I believe that the collegium system is flawed. I believe it does not reflect the true voice of the people. I believe it is I scratch my back, you scratch my back, you appoint my nephew, I appoint my grandson. But at the same time, today we are seeing an absolute majoritarian government which does not believe in the system. They've clearly said so, that we want all these basic structure and all to be thrown out and a new system to come. So I end by saying this, and we'll talk later maybe. I'm sorry I've taken more time, and I end by saying this. Ultimately, we know, and it's a sad commentary, and I don't want to give such a bad commentary to the young minds of the college today. But I say it with a great deal of bitterness, and I hope you people are much better than we by our generation was. The judges, believe in their nepotism or whatever it is that you want to appoint people you know, your kith, kin, whoever, your brother, even if he's 43 years old. The politicians want to appoint your Victoria Gauri and whoever. I say, please do that. But don't appoint any independent people. Don't appoint people who are first generation lawyers. Don't appoint Dalits. Don't appoint women. Don't appoint tribals. Do whatever you want. But at least in your quota of 10 politicians, please appoint one competent person. And judges in your quota of 10, please appoint one competent person.
Thank you, Mr. Ghose. That was a very, very firebrand speech. I just want to inform the debating society here that since you're live streaming this, you will also be charged with contempt. So please book your tickets to Madurai. Am I right, Mr. Hegde? Thank you very much, Mr. Ghose. In fact, I just want to share a small little experience here on what he reached out to law students to tell them. Recently, I presented a paper on anti-conversion laws. And interestingly, a couple of students helped me with that. And I asked them, I want to put you in the footnote as acknowledgement that you have helped me. And they were like, maybe not, sir. So, I think students are very aware that they have to make the right kind of noises. And unfortunately, that is sad. It is sad that we are putting down our creative liberty, our legal thought process for possible action later. And I think in a liberal democracy, this fear should not be there, at least among students. That's something which I would really like to reach out to you. Do not have that fear at all. You really do not know that when you're eligible for a judge, which government is in power. So, just letting you know. But yeah, thank you very much, Mr. Ghose. Mr. Prasanna, all yours.
Thank you so much, and good evening to everyone. The order of speaking has given me perspective on how Dhoni might have felt on his first entry. He had to follow Tendulkar, Dravid, Lakshman, not to mention Sehwag right at the top. And having heard three senior advocates deliver their speech, here I am with my sum total of 15 years of sort of experience at the bar, having to follow them for in their clarity of thought, the rhetoric, and the deep insight that they gave you. So you will forgive me if I pale in comparison. Let me start by picking right off from where Mr. Sanjoy Ghose has ended his talk and mention the name of a person who's increasingly become unmentionable these days, Jawaharlal Nehru. If we have to credit him, and we have to credit him for a lot of things in this country, he did, in fact, set in place two conventions. One less willingly, which Mr. Sanjoy Ghose has given an example, but it's also to his credit that he saw the wisdom in the course of action being proposed by the judges. Nobody, and when I say nobody, I mean beyond the 5 judges and maybe a couple of lawyers, would have disputed Nehru if he said, I want to bring in Justice M.C. Chagla as Chief Justice of India. Popularly, nobody would have stopped him. There would have been no street protests. But, sorry? He himself, that's also there. But on that count, what he also did was to ensure that the convention of the senior most judge, and it started with him. You'll actually not find too much evidence of this. I think one of your alumnus, Mr. Abhinav Chandrachud, has written this book on the colonial judiciary. You don't find too much evidence of senior most judge necessarily becoming the Chief Justice prior to 1950s. And at least as far as post-independent India is concerned, that convention was set in place by Pandit Jawaharlal Nehru. The second convention, of course, and one which has come to light thanks to the writing of George Gadbois, was that the Chief Justice's opinion was considered sacrosanct. If the Chief Justice of India said, I want this person as a judge, almost inevitably, maybe there was a little bit of discussion, they never said no to any name. Nor did they suggest to the Chief Justice, you should suggest this name or that name. And this particular convention held across 3 prime ministers, Nehru himself, Lal Bahadur Shastri, and the first term of Ms. Indira Gandhi. The term of Ms. Indira Gandhi in 1971 saw the change, and you will see that you will read about this in more detail. Please do pick up George Gadboy's book about the judges of the Supreme Court of India between 1950 and 89. You will see that this convention changed. Now it was no longer about the recommendation of the Chief Justice. It was the Chief Justice recommending someone on the recommendation of the government in turn. And this system persisted until it basically broke down in the 80s. It broke down in the 80s because of a government which only wanted to have its way, again a majority government, and which was essentially left a large part of the court vacant because it just would refuse to process the appointment system. What I want to bring about in this, and to go back to a point that Mr. Naphade mentioned right at the start, is that our constitution, the text of it may be amended by parliament, but the practice of it is informed by not just the judiciary, but also the executive. And I think this is where, I know it's mostly lawyers, there are no politicians here. This is where, and I think as citizens of this country, we should be aware that we need to hold the executive also accountable. In that you have deviated from something which was the norm, and we believe this is wrong. So, to come back to the collegium itself, I want to raise this controversial point. Is there still a collegium system anymore? I was going to mention some of what Mr. Sanjay Ghose has already mentioned, so I won't repeat it. The collegium system fundamentally was about the judiciary having the final say in the matter. But if the judiciary no longer has the final say in the matter, is it still the collegium system anymore? When the executive with impunity can ignore recommendations, can ignore reiterations, can segregate names and change the order of seniority, can delay appointments until seniority of a particular candidate is lost, do we still have the collegium system? I have called it the search and selection system, at least since about the year 2016 or so, when the judiciary did not stand up for itself. This is the problematic part. The judiciary has not stood up for itself when the collegium system has come under pressure. But let us assume that the collegium system worked as intended. There are, as I see it, 4 problems with it. 2 of this relate to the process itself, and 2 of this relate to the outcome of the collegium system. The 2 problems of process are that it is non-transparent and it is non-objective. I think enough has been mentioned about how it has been non-objective, but non-transparent is something that has been addressed to a certain extent in the last 3 years, but not enough. This is very clear. 2 other points, which is on the outcome, is that it has not led to a diverse judiciary and it has led to an inefficient process of appointment. Now, diversity is a point that has already been made, I will not labor that. But inefficiency is something we have to also consider. When the collegium system was set up, perhaps the sum total of High Court and Supreme Court judges who were required in the country was in the order of 300 to 400. Now the number is close to 1200. Until 2 years, last year, when a whole host of appointments were made, the collegium system never managed to ensure more than 700 judges concurrently serving in the High Courts and the Supreme Court. And this is a serious criticism which unfortunately hasn't been fully addressed, but it's a weakness of the system nonetheless. Keeping that in mind, I think we've been asking ourselves the wrong question so far. I think it's not about whether the judiciary should have supremacy or the executive should have supremacy. The short answer, according to me, is neither. The answer, according to me, and this is where I would like to push this debate forward, push this idea out there for all of you to consider, is perhaps it's time to let the people into the process. And by letting people into the process, I mean 2 things specifically. One is increased transparency. We ought to know. We may not agree with all the appointments. It's impossible to get 1.5 odd billion people to agree on anything. We may not agree with some of the appointments, but we need to know how and why they were appointed. And this is where I want to make the more controversial suggestion. People should be part of the selection process. Not that it's a put to vote, but there should be representatives of the people whether they are civil society, whether they are eminent has become a controversial word, whether they are people who have achieved something in their lives, or somebody who speaks for the non-lawyer, the non-politician, the ordinary person of this country. Because at the end of the day, the judiciary doesn't exist to perpetuate itself. It doesn't exist to perpetuate the goals of the executive. At the end of the day, the judiciary exists for us. So I'll end this with an appeal to say that perhaps the way forward is not to debate whether the collegium is good or bad, but to find a way of appointment that puts the people at the center. Thank you.
Thank you, Mr. Prasanna. Those were very of having the people hold the executive accountable. I mean, of course, it will be a big challenge on how we do it in terms of, as you very rightly put, delay defeats the entire purpose of the appointment, and this is how possibly we've seen for the last few years, the executive controlling the appointment of the judges, and even as we speak right now, some of them will become ineligible in a short time, so the control will be there. I'll probably come back to you and ask you how we do this process a bit later. Thanks. Dr. Mane.
So we can exercise our liberty as no issue. Second point is, without making any reference to any individual or any incident, I will try to bring your attention to certain fundamental principles of constitutional law that needs to be understood while discussing and debating the whole issue of independence of judiciary. How many of you have heard the name of Justice Coke? How many of you have heard the name of Justice Coke? C-O-K-E. Very few. And in the known history of judiciary, Justice Coke was the first Chief Justice from UK who had a quarrel with the King over the judge's power. And King was trying to prevail over the judges, and the Justice Court said no. King is subject to the rule of law, the law. And that is the first known historical battle between the executives and the judiciary. Second, that today's crisis seeds were sown by Jawaharlal Nehru in the Constituent Assembly itself, when he categorically said, what he said? He said, in no circumstances a judge or a Supreme Court shall be a third chamber. He was very categorical. When he made this statement, there another angle was presented by T.T. Krishnamacharya. T.T. Krishnamacharya, a prominent member of the Constituent Assembly, and he said balance needs to be maintained. And that was rightly taken up by the architect, Dr. Ambedkar, by saying that there cannot be imperial imperio. The phrase is used as imperial imperio. This approach was adopted by Dr. Ambedkar. Now, having seen this background, two more new points needs to be understood, and that is one, most of us believe and try to study or understand the doctrine of separation of powers, as we have one article in the Constitution. But our whole constitutional premise is not premised on the pattern of the United States of America, where there is a strict separation of powers. We have the division of powers. Now, who should understand this? The executives and the judiciary. Other are ones too. So there is no strict separation of powers as such as represented in some of the forms of the constitutions. Secondly, our constitution is a premise on the system of checks and balances. Why? Why framers incorporated this kind of mechanism in our constitutional framework? Probably they may be aware that what kind of people will be there who will be operationalizing the constitutional institutions. Knowing that, or knowing this kind of a danger ahead, they have enshrined, incorporated the system of checks and balances. Now, if you consider the system of checks and balances, my simple question is, can any organ could claim an absolute power over a particular constitutional issue? Whether it is the appointment of judges or whether something else. And if you go by the doctrine of checks and balances, certainly answer is no. So nobody can say that it is in my purview, it is my area. No. इधर तुम गाना नहीं गा सकते मेरे अंगने में तुम्हारा क्या काम है, because that is not permitted within the constitutional scheme. As our Advocate Naphade ji reminded, the conflict between the judiciary and the executive, and we should remember the Kishu Singh's case of 1965. Kishu Singh case of 1965, again, how many of you? Just raise the hands. You are the GLC students. Yes, only one hand, okay. Now, on the issue of breach of privilege, a High Court judge, Allahabad High Court judge releases an accused man, and for the acquittal, the Speaker of the UP Assembly summons to the judge of the Allahabad High Court. Now, whether this kind of situation was visualized by the makers of the Indian Constitution. Forget Kishu Singh, come to 73. And when doctrine of basic structure came, which is the judicial outcome, Indira Gandhi called it as judicial innovation. And therefore they always tried to through this doctrine. For that a new bench was also formulated, but suddenly it was abandoned. Now, doctrine of basic structure controls the powers of the executive. That's well known. Now, after 1973, after this doctrine, the parliament has always made an effort to bypass the judiciary. And in this conflict, we have the 1993 judgment. And when we look at the 1993 judgment, today's topic we can categorize into two categories, prior to 1993 and post 1993. Now, prior to 1993, when there was no collegium, we have the report of Law Commission 14. What it says? We have 79th report of the Law Commission of India. What it says? Region, religion, caste, nepotism, corruption, favoritism, uncle syndrome, all are there. These are coming from the reports of the Law Commission of India. After collegium, we have 109 report, 2009. And that again repeats the same thing. So what is the difference? What is the difference prior to 1993 and what is the difference which we have made after 1993? Whether there is a fundamental change in the situation. Straight question. Now, let me come to the constitutional issue. Indian democracy is yet to be matured. That is not fully grown up democratic republic. We lack that constitutional maturity, which makers of the constitution called it as a constitutional morality. Now there is a debate, a parliamentary majority versus constitutional morality. Some judges are trying to hold the torch of constitutional morality. And some parliamentarians or the governments or the members of the government, they consider it is as a judicial tyranny as it was described by former Finance Minister Mr. Jaitley. Now my simple conclusion is this. From 1950 to 1993, we have tried with the one system. Executive dominated judicial appointments. 1993 onwards, last 3 decades, we have tried with another model, that is a model of collegium. Why not to change further? Make it a blending of two, eliminating all those flaws which have been identified. Then we can evolve a better model. Ultimately, every nation's constitution or constitutional life grows in a dynamic manner. We should move ahead. Rather than blaming each other, playing the game of tu tu mai mai. Instead of that, we must come to the ground reality that we need to proceed further with a new kind of innovative methods, forgetting the my area of sovereignty, which recently Vice President of India has claimed. Now he claimed not only in the name of sovereignty, but he also tried to claim in the name of doctrine of basic structure. But checks and balances are also the part of basic structure, how he can afford to forget. So my humble submission is, tried with the 2 models, let us have a 3rd model which will be defect-free from earlier 2 models. Thank you very much.
Thank you very much, Dr. Mane, and for reminding us of the checks and balances that are there in the Constitution. Although I would love to ask you, what's your opinion of our Vice President commenting on the judiciary? I really want to hear from you a little later on what is the mandate and where does that come from. That would be quite interesting. So I would like the audience to probably frame some questions, and we will take the mic around and take it from them. There's a prize for the best question. Yes, yeah, we always do that. Debating Society does that always. In the meantime, I'll just have a round of questions to the panelists. Sorry? No, you're not going to get it because you're going to be in Madurai, my friend. Okay. Mr. Naphade, can I raise a question to you? The critics of the collegium system have constantly said that there is nepotism, absence of a democratic functioning, there is no transparency, the judges do not have time to actually appoint the judges, the entire process is informal, there are no minutes kept. I mean, there are several critics of the collegium system. In your experience, and your experience is very wide, how much of this is true? And how much of this is arising from disgruntled advocates or disgruntled litigants? Because when a judgment comes, there's always one person who's unhappy. So what is the percentage of the criticism of the collegium system and how relevant it is?
Mike.
Although, as a student of constitutional law, I am clearly of the opinion that the collegium system is contrary to the basic structure doctrine. But I must concede very fairly that by and large it has worked very well. There are some exceptions, and exceptions can't lead to such a severe criticism. We can't throw baby with the bathwater.
So you do feel that the criticisms are probably not as justified as we are made out to believe.
So there are a few cases
Sure.
which were, one can say that the appointments were not justified. They did not conform to the standards expected, both with reference to the caliber, with reference to integrity, and several other factors. But by and large, it is working all right. The only question is how the collegium system, the judges stand up to the executive.
Right. Thank you, Mr. Naphade. Mr. Hegde, I want to ask you a question which, since you're coming from Delhi, you should be able to answer. Now in this trade-off, sorry, not the trade-off, the standoff. The collegium has made recommendations, the government is sitting on the names. The collegium has reiterated the names, the government is still sitting on the names. This impasse is going to probably ultimately come to the favor of the government because the particular appointees, whether it is Kaul or whether it is the Shekhar, is, at some point in time going to lose interest or be ineligible for whatever reasons. Now, if the government is not listening to the court, do you think the court may or can proceed in contempt proceedings? Has it happened in the past? Can it happen now?
Look, it hasn't happened in the past, but there's no reason why it should not happen. The equivalent I'd like to give you is from the United States. When desegregation was ordered, that children had to go on the same school bus, whether they were Negroes or not. Sorry, whether they were African American or not. So President Eisenhower did his best to get the Chief Justice, Earl Warren, to hold on to the southern side of things. But once, he didn't like the judgment, but he said that once the Supreme Court has ruled it, I have to enforce the law. And the Supreme Court later even sent the National Guard into southern states which were not allowing desegregation. So it's like if the Indian Supreme Court, finding some state government which did not listen to it, said, okay, send in the CRPF or send in the army there, till they listen. There is Article 144 also in the Constitution, which requires all authorities to come to the aid of the Supreme Court. We have not yet relied on it. But right now, this is a question of appointment of judges. At least the officers concerned could definitely be asked to explain in contempt. In an analogous situation, I remember that during the early days of the 10th schedule, there was a question of whether speakers would listen to court orders. There was a speaker from Manipur, Mr. Bora Babu Singh, who refused to obey the Supreme Court orders. Notice was issued to the speaker, notwithstanding the fact that he held a constitutional office. He was summoned to the Supreme Court and his presence was ensured. So it is not as if there are no teeth. The question is, has the time come to show the teeth or to bite?
Can I just add one small thing? It's not specifically related to appointments, but it's a bit of... Sure.
In my view, no action for contempt can lie. The recommendation of the collegium is not a judicial order. It's purely administrative. Therefore, the court may have to think, the collegium system may have to think other methods of enforcement, but it can't be. Perhaps some public-spirited person can file a writ of mandamus, and the mandamus can be issued, and if mandamus is disobeyed, then the contempt.
Sir, a minor disagreement. You're absolutely right. The recommendation of the collegium is an administrative action. But the contempt is not for disobeying or not acting for the recommendation. It is contempt for disobedience of the judge's case. The dictum in the judge's case, the ratio of the judge's case, which says once it's reiterated, is binding on you. And that is a constitution bench judgment, is definitely action can be taken in contempt. This is my personal feeling.
Yeah, and I'll just very quickly add, not to the specific discussion in this specific context. Did you know that a high court in India once went on strike? The Bombay High Court, during East India Company rule, went on strike. And you know why they went on strike? The Governor General refused to follow an order of habeas corpus. It was then only 2 judges. They issued the order. The then Governor General refused to comply. One judge passed away. The other judge said, until you comply, we are not opening the doors of the court. If a colonial judiciary in a colonial context could stand up for itself, the methods and the means we can debate, we can have different points of view. Stand up for yourself. If they stand up for themselves, then you can figure out the method. But that first task, and we've discussed the instances where the judiciary stood up for itself. When the remaining judges of the Supreme Court said, we'll resign. If you don't make us Judge Justice Patanjali Shastri the next CJI, find 6 other judges, we'll all resign. And they said it as starkly as that. So it's not so much about the exact method. It's about saying we have to stand up for ourselves. And I think that is what the judiciary is feeling to do.
Here our law minister is in the attacking position, not the judiciary.
Well, so there is definitely a element of
Response to-
disagreement here whether contempt proceedings would lie or not. Yes.
Sanjoy's response, rejoinder in a way. What he says is that not acting on the recommendations of the collegium, there is a violation of the third judge's case. Now, third judge's case is merely a declaration of law under Article 141. Every infraction of a law does not constitute contempt. There has to be a positive mandamus, that is with reference to a particular candidate. That the mandamus is that the government of India is directed to appoint so and so. If that is breached, contempt will lie, not otherwise.
Thank you very much for that clarification, Mr. Naphade. Actually, the true strength of power lies in not having to use it. And I do sincerely hope that the event doesn't come when one wing of the government has to really do this with the other. Mr. Ghose, I'd just like to get your perspective on the current open season. It's open season for shooting. It's open season from the law minister, from the vice president. It's open season on WhatsApp, on the attack on the collegium system. There are allegedly confidential information from the judiciary put out in public domain on why certain judges are not elected. Now, this is not something which we as a country can be proud of. We would rather have things work in a more civilized manner. Where do you think this is going? Is the government scared? Is the judiciary unsure what's going to happen now? In other words, does somebody know where this is going? Or nobody knows where it's going and they're just drawn the battle lines and hoping for the best?
Yeah, isn't there a song which says, "Hey, what's going on"? So, well, I think, Professor, you have actually summed it so beautifully when you quoted Confucius that it's actually a Chinese curse. May you live in interesting times. It's a curse. May you live in interesting times. So we are living in interesting times. And in fact, I really can't say that what is happening, except I can tell you that don't go by the obvious. Don't fall for the obvious. Don't see on live law and bar and bench reporting or some statement of the law minister or some statement of the collegium. Look behind, read between the lines. You're intelligent people. Today's law students are much, much more intelligent than we were. Okay? See behind the lines, exactly what I said when I was addressing you primarily. Like, for example, let me tell you something. It's not in the public domain. The collegium recently, and what Professor Daswani was talking about, again, in a welcome break, actually recorded detailed reasons with regard to Saurav Kripal, John Sathian, and a candidate from your High Court, for your High Court, Bombay High Court. But there have been several cases where the reiterated recommendations are coming back to the collegium, and the collegium is quietly sending it back to the High Court. In those cases, the collegium is not brought out these big statements saying that, oh, once we are reiterating is binding on you. So actually, I really can't say what is going on, but I can say this much, that, you know, it's time for less of this theatrics, or less of this heat, less of this performance. I think the Chief Justice and the Law Minister are very respected authorities. Chief Justice is the Bhishma Pitama of the judicial family. The Law Minister is, so far as we lawyers, judges, law students, is the head of the executive for us. Both these authorities should actually act with a little bit of maturity, and both of them should sit together and work this out in the interest of the nation. At the end of the day, please think of it. I mentioned the matter yesterday, and I didn't have to mention the Chief Justice gave an early hearing. I had gone to mention a matter where a fresh bail application in the Patna High Court is not being listed for 2 months. So this is what we are dealing with. Please think of the litigant. And I said this, Mahatma Gandhi, who was a lawyer of practice in this court, in the Bombay High Court, City Civil Court, said that when you think of any action, how it will impact on you, think of the weakest person and think of how your action will impact you. So that is where the Chief Justice and the Law Minister should think of that litigant who's struggling for justice, who's struggling to get his case even listed for the first time. And all this has to end.
If I could take that question on a different note. You know, there are two Sanjays out here. And the thing about Sanjay was that the original Sanjay was that he could look out into the battlefield and tell the blind people what exactly was going to happen. You know, in Indian mythology and in Greek mythology, there are two characters. There's Sanjay in the Mahabharata, there's Cassandra in Greek mythology, who had the gift of prophecy, but she also had a curse that nobody would believe her. And today, let me combine Sanjay and Cassandra. This is a sinister game which has started. And the thing about this government, or the party that it represents, or the ideology behind it, is that it doesn't think short term. It thinks long term. Why is it that there is an attack on the independent judiciary that we have come to at least expect as a modicum of democracy? Shortly on April 24th, we are going to have the 50th anniversary of the basic structure doctrine in India. There is an attack on the basic structure doctrine as well. And given what I have seen, particularly with regard to various campaigns, nothing is short term. If you see the Ayodhya campaign begins way back in 1949, almost as soon as India becomes a republic. And there's a sudden eruption or a sudden Ramji Prakat Hue, which the government of that time could not insist on the rule of law, and it has worked its way through. Today, what I see is something similar about a plan to remake India and remake the judiciary to something which is Bharatiya enough or Sanskari enough for the government that we currently have. I hope I am wrong. I hope that you younger people prove me wrong.
See, there is a fundamental problem. The political sovereignty is still with the people. The question is how this political sovereignty can be expressed in concrete terms. It's not possible that all 120 crore Indian population one fine morning decide to exercise their political sovereignty. Revolutionary situations. So this political sovereignty is transformed by the constitution into parliamentary sovereignty. However much I may dislike the politicians, the political parties, the only way by which the political sovereignty can be expressed is only through a process of elections held in a democratic state. No one can say that a few people in this country alone have a right to decide what is good for the country. Ultimately, democratic process has to operate. And if democratic process operates and you have a government and you have a parliament which wants to do away with the collegium system, you have to respect it. In this context, I'll give you one example. When the postal bill was presented to Gyani Jail Singh Ji, who was the President of India, he thought that this bill contains certain provisions which are not in public interest. Some provisions are obnoxious, and he decided to withhold his consent. One of the silences of the constitution is that there is no time limit within which the president can give his assent. And you all know, president is also a part of the parliament. And unless he gives the assent, the bill doesn't become law. Because he withheld the consent and he started raising this issue, in other words, he took it to the People's Court. And the resistance, the political resistance grew. And therefore, Mr. Rajiv Gandhi, who had a massive majority in the parliament, had to give up the idea of having that postal bill as becoming a part of the law. And till today, no successive president has granted assent to that bill. That bill is still born. The another example which I would like to give it to you is Chief Justice Munir of Pakistani Supreme Court. He was once asked that if you are a president and you find a bill which is not in public interest, would you sign it? He said that I will refuse to sign it, but I will resign and take the matter to the People's Court. So ultimately, in a democratic process, if people do not like a particular system, it is for them to raise their voice through a democratic procedure. That's all I wanted to say. Thank you.
Thank you, Mr. Naphade. Very good. That's very inspirational. And I'd like to, in fact, take this very question to Mr. Prasanna because you spoke about people power. It reminds me of a Diana Ross song. Where have all the good men gone? So, how do you really get the people to be activated to that extent? I mean, in our parliamentary democracy system that is there, you need 30%, 37% of the popular vote to become elected and get a majority government. So how do the people really get out of their daily living structure of poverty to even understand a judicial system? I mean, how many people, yes, we talk about it, in law students talk about it. What about the ordinary man? He just talks about it without understanding it. So how does a complex judicial system become the mandate of discussion of the popular vote? Well, theoretically, it may seem a great idea.
I'm the worst person to answer it because I tick every box of privilege in this country. But I'll tell you what. In our lifetimes, forget lifetimes, in the last 5 years, we have seen people take to the streets on what we as lawyers say, oh, this is a complex issue. I think we complicate it. When the CAA bill, law, whatever has happened, I think I was at no fewer than about 8 to 10 events over the course of 4 months, like Mr. Dr. Swami, explaining to people this is what is there in the law, these are some of the misconceptions about it, and this is what is actually problematic constitutionally about this law. Not one of this was a legal audience. I've spoken to science students, I've spoken to civil society organizations, I've spoken to mostly non-law audiences. And I know this sounds like a cliche, but people feel injustice in the pit of their stomach. We complicate it. We add a lot of structures and institutions and thoughts to it. We complicate it. The Farm Bill, I promise you, I could not read beyond the first 3 sections. Each of those 3 bills. My eyes went watery. I was like, okay, there are people better qualified than me to comment on this. I'm not going to go into it. But you had a mass mobilization across the country, most visibly in Delhi, sure. People understood it. And you've seen those videos where some newspaper, some cocky newspaper reporter says, what do you know about the bill, and gets schooled on the spot by a farmer who says, this is the problem, this is the problem, this is the problem, this is the problem. Because for them, it's a matter of life and death. They understand the issues. I think we have to credit the people to understand injustice at the pit of their stomach, what perhaps is missing, and this is where I will add. I want to take a line from Dr. Ambedkar's famous quote. We all get to the educate and agitate parts of it very easily. The organized part is the most important. The organized part is the most important. That is what is lacking. That is what Dr. Swami was talking about that day, the CJR event, where he was like, this independence of law is not about one of us individually going and holding up a placard. It's about the bar as an institution. Bar is the most readily organized body of lawyers who understands these issues. What has the bar done? I'll end with one last example. When emergency was imposed, and since we took his name, Justice MC Chagla had retired by then, he was head of the Supreme Court Bar Association. When emergency was imposed, he was able to get the entire Supreme Court Bar Association to go on strike for that day. It was symbolic, not that the emergency was lifted the next day. But he showed what an independent bar could do. We can express our dissent. Let's not expect the outcome will be this. But if we don't stand up, if we don't do that, if we don't use our existing institutions of organization, our ability to organize to the maximum effect, we can't expect that suddenly a surge will come up and we'll all be carried to nirvana.
Yeah, that was quite inspirational. Though, one little comment I cannot but give is that you're looking at institutional motivation. But as each and every institution gets taken up, I wonder who will be left to motivate the people at some point in time. Having said that, Dr. Mane, one last question for you, and then we'll open it to the audience. You made one very important point of judicial tyranny, and another point you made about that Indian democracy is not yet matured. So, do you think it's Indian democracy that's not matured, or it is the Indian people who have not matured to accept a democracy? Or is it that Indian people have not been allowed to mature to really take the benefits of the democracy that is available to us? Because ultimately it's the judicial system is an integral part of this democracy. So where do you see this?
First, Professor, let us know about the constitutional literacy program in our country. How many people are aware about our constitutional mechanism? Answer is simply no, number one. Number two, in the last 75 years, what we have done about to build up that whole constitutional literacy? Apart from who is in the power, again answer is no. I always used to say, and I'm also saying now, At least in America, we have a one constitutional convention center at Philadelphia, where we visit and then we come to know how the US Constitution came into existence, what for, what are our goals, and what is the existing presidency is doing. There is not a single institution of that type in our country. So how you are going to build up the whole constitution, whole society with this kind of a spirit? That's the one question. Second, coming to the whole controversy, I was just listening to other panelists. My humble submission is this. Why this controversy has now reached to this level? And this is a pertinent question. And what I understand, whatever it is, my perception is this. The current era by the current governments is for unlimited powers. Unlimited powers. Now when I say unlimited powers, I will give you 3 examples. Ghosh and others will look into this angle. Earlier we had some kind of a control over economy. Now government don't want to have any control over the economy. It want to limit absolutely to the market economy. You may say so in the name of globalization, but that's not correct again. Earlier we used to have a civil servant through the exam process, collectors. Now we are having a backdoor entry for the collector people, the IAS people. Why? That is second. Third, and that's most important, earlier each and every prime minister or even any other minister's cabinet secretary used to be from IAS cadre. Now they are coming from the non-IAS cadres. Even chief security advisor of current prime minister, he is not coming from IAS cadre. To whom they are accountable? Are they accountable to the IAS cadre mechanism? Are they accountable to the parliament? Nothing. They are not accountable to anyone. How? Now that's the point. In this scenario, now let us see, during a COVID crisis, what was the issue? Government was putting, oh, we are doing this. Matter reached to the Supreme Court. Supreme Court asked categorically to the Modi government, present your plan. And he said, no, we are the executive, we will decide. And Supreme Court said, no, you have to present. We will ascertain whether it is right or wrong. That was a limitation on the governmental power. Present era government don't want any limitation, and in that matter, judiciary is coming in the way. That's the issue. Yesterday again, look at the Election Commission of India judgment in the matter of Election Commission. Now tell me whether 2 days back judgment delivered by the Supreme Court of India in the matter of appointment of election commissions, whether it will be liked by the government? Certainly not. Because that defeats the purposes of the government, and that defeat comes from the judiciary. And therefore we would like to take over the judiciary by exterminating an element of independence. And terminating, when I use the word, this could be by any method. And that is happening, and therefore the controversy.
Oh, that was very, very powerful. I think you deserve a round of applause for that. Very, very, very powerful words. So I guess, I'm just concluding, Dr. Mane, please don't get me wrong here, that are you comfortable with judicial tyranny over executive tyranny? Because at this point in time...
But again, I said, go back to the spirit, maintain the balance. Or come with a new alternative system. We need to improve upon it.
Thank you. Can we take just one round of questions? Okay, you will address the panelists that you want to address the question to. Make a question brief. We do not want comments. Yes.
My question is to senior advocate now. So, Yeah, my question is to Senior Advocate Naphade. So you suggest, so this debate falls to the basic structure and ultimately constitutional sanctity. You suggested that the constitution is by the will of the people and also talked about political sovereignty. So my question is, and it's the ultimate question, that by will of the people, is the constitution malleable to any extent and even replaceable? And if yes, how do you quantify this? By a simple two-thirds majority in both the houses or maybe a referendum?
I think I have already answered that question, but I will repeat. See, ultimately, political sovereignty can't be exercised on the public streets. It has to express itself through a democratic process. And the only known non-violent democratic process is election. If people do not want a particular political ideology, it is for them to exercise their voting right at the time of election. I said in the context that we the people, we were not there when the constitution was framed. So our ideas may be different from the ideas of the constitution makers. But subject to basic structure doctrine, we have a right to have a relook. And according to me, the method of appointing a judge is not a part of the basic structure. That the judges should appoint a judge is not a part of the basic structure. According to me, it's a purely an executive function, and discharge of such executive function can only be by the government.
Thank you, Mr. Naphade. Any other question we have? Yes.
Sorry, my teeth are chattering. It's a bit too good for me. But can you comment about this suitability versus eligibility argument given by the court in throwing out Victoria Gaury's case? Could the court have gotten around that somehow? And what do you have to say about? Sorry.
Which man to say?
I guess
Anyone can take.
Yeah, I guess someone can answer. And what do you have to say about the chaos that ensued that morning, you know, with the constant shifting of benches and shifting of courtrooms? It was fun to observe on Twitter, but like, what was happening? Would it have been improper for the Chief Justice to hear that case?
Looks like nobody wants to take this.
No, since he wants to go to Madurai, I was letting him.
I was just going to say, since I live furthest from Delhi, I might escape attention for this. It was a gigantic mess. And it reflects very poorly on the Supreme Court. Because this is like, to translate, because my Hindi is very bad, this was the classic case of the court basically axing itself in its feet. In no way has the court come up, nor have they said that there is nothing wrong with Justice Victoria Gaury's elevation, nor have they said that if there was a problem, we fixed it, nor have they said we actually stood up for ourselves, even heard this case. On the specific legal point, and I was kind of surprised that was the argument. I mean, there are better senior advocates than me, but as an external observer who knows a little bit about the law, I was somewhat surprised that they chose to go on that particular point, that she is not suitable, because there is enough service law jurisprudence on this point. Courts won't go into suitability, they are going to go into eligibility. Now you can change the meaning of the word eligibility, but that takes hours and hours of argument over several days. You're not going to get an interim relief, right? You wanted that interim relief. So for me, it felt like a strange choice to pitch your argument on. When we had this discussion just now, the point would have been that how could she have been appointed? Because the collegium itself has said she cannot be appointed until Mr. John Satyan and others were appointed. That to me was a simple and straightforward thing. right? So, which to me has painted the court in the poorest possible light. It has left it sort of losing credibility in a situation like this. As the discussion has shown, it's not like it has removed any doubts about the suitability of the Justice Victoria Gowri to be a judge of the Madras High Court, nor has it shown that it has stood up for any problem with the process. I think they've decided to leave me hanging here for the
Okay, Professor Daswani says I should just give a little background of Justice Victoria Gowri. Now, Justice Victoria Gowri's name was recommended from the Madras High Court, collegium, to the Honorable Supreme Court. Supreme Court had cleared the name. The controversy was that in her social media handles, she referred to herself as Chowkidar Victoria Gowri. She had a lot of hate speech. She referred to herself as an active member of a women's wing of a political party. So that's just the background. So, but I completely agree with Alok that we should not have gone into that on the issue of eligibility. It should have been on an absolute legal point that recommendation itself was a conditional recommendation. And since the basic of contract you write, right? A conditional offer, conditional acceptance. So it should have been argued on law that is a conditional recommendation. The recommendation cannot become active or actionable until that condition is met, which was not met. Instead of going into all that, that's my personal belief.
I mean, just in defense of those who argued it, because there was already a precedent where there was a warrant for appointment of a judge, and then the Supreme Court had stepped in. That was the earlier case of Keshri Nandan Srivastava. So, and there the question turned on eligibility. Did you have, no, Meghalaya. So the man, did he have 10 years of service as a lawyer, and was he eligible? So, in a sense, the argument got stuck in a precedent. Yes, as far as the handling of the case is concerned, it could have been infinitely better handled on the administrative side itself by the Supreme Court.
Also, on one point, I really didn't understand what that precious 5 minutes was. They sat at 10:25 to say, see, we have sat in advance of the swearing in, which was in Madras at 10:30. So, I do believe that even at the administrative side, if the Chief Justice of India had just made a telephone call to the Chief Justice of Madras High Court and said, just hold on, brother, wait till 2 o'clock, let this case happen. As I said.
One point here, Professor. Here again, we should not take it a just superficial view. Once again, I am trying to remind you, during Indira Gandhi period, the whole issue erupted like this about certain judges. And the philosophy of the then political party, the then government, was propounded by Mr. Gokhale, the law minister. And he openly said, judges should subscribe to the philosophy of a political party, not to the constitution. And that was a national disaster. We know everybody. Professor Alok Prasanna must be knowing very well. So, yeah. So that concept of committed judges versus independent judges came. Now we apply the same criteria, whether some selected A or B or C subscribes to the philosophy of the constitution or a political party, that is naturally becomes a criteria for the selection. So if a person subscribes to the merely ideology or philosophy of party, definitely criticism will be there. But political personalities, we had a Justice Krishna, he was a minister. He was a minister in the first 57 leftist government. Namboodiripad government. EMS, Namboodiripad, he was the minister, law minister. But that doesn't become a bar for his elevation to the judiciary or the Supreme Court. But when you subscribe to political ideology or philosophy, that is a matter of debate.
But who will decide that you are subscribing to some ideology? Who will decide that? Who will decide that somebody is subscribing to some political ideology?
Good question. Who will decide?
Yeah.
And if there is a something on record, something is on record.
Where is that record? Where is that record?
If you want to examine in detail, we will sit in private and we will discuss.
The valid point here is that, look, if somebody subscribes to an ideology very, very patently, and there are some people who subscribe to an ideology latently, I do not think there is any person in this world who can say, I am free from bias. So, but we also have to have faith in a person who has got a legal upbringing, who's been a judge for many years, and in majority of the matters, he is bound by the law. It would be those 10% of the matters wherein the ideology can make your judgment shift either left or right. It is not that you are making judgment only on your ideology or only on your bias. There is a law to be followed as well.
Yeah.
So, that risk of the ideology, we are taking on that 10 or 15% of those matters.
With your kind permission, may I ask a question? This is in response to what Dr. Mane said. Who decides what is the constitutional philosophy?
Okay, it's just coincidence that there are two ends of the table. That's how it
landed. Senior man's experience question is a very difficult one. He categorically asks, who will decide whether it is a constitutional philosophy or not? If that question is very difficult to decide, at least somebody can decide on your political ideology. And if that answer is somewhere available, then naturally you will be debarred from that process. So who decides whether it is a constitutional philosophy or not? Although it is a debatable, other side you may have a certain thing, a material which you rightly said patently.
Well, notwithstanding, your political ideology would not change who you are, irrespective of whether you are a product of the collegium or product of an NJAC or product of the executive appointment. I think we carry our political ideology or religious ideology wherever we go. I could take one last question before we close for the day.
Yeah, so, hi. Yeah, so it was brought up that Ambedkar commented on India's lack of political consciousness. So if that's the case and the collegium is riddled with nepotism, clique mentality, upper caste behavior, upper classness, then how do we reconcile these two polarities if they even do exist? My question was given before the panel discussed the farm law. So is there even a lack of political consciousness amongst Indians, or where do we stand on that scale? I think that's one part of the question. And the other is, if there is a lack of political consciousness, will increased transparency, which is something that the panel discussed, will it help if we're still a country that lacks that? And I think my questions would be addressed to Alok and the panel in general.
Thank you. How many of you here have heard of the Pattal Gadi movement? 1, 2, 3. Great. For the rest of you, in Jharkhand, in rural Jharkhand, in perhaps the most backward part of the most backward state in the country, something called the Pattal Gadi movement emerged. What was the Pattal Gadi movement? The Adivasis of Jharkhand carved on stone the 5th schedule of the constitution. Anybody tell me what the 5th schedule of the constitution is? It's about tribal rights in what is called the Chota Nagpur area. It was in response to the government's move to reduce the rights of tribal peoples in those areas over their land. I say this, if the people with the least resources in this country, the people who are dismissed as not aware of the constitution, know enough of the law, know enough of the constitution, know enough of their rights to mobilize, to find a unique and culturally appropriate way of protest, what's stopping the rest of us?
Can I just add to this? It's a misnomer to say that the common person doesn't understand the constitution, and Alok did speak of people feeling injustice in their guts. You've been informed, I had been sent as a negotiator to Shaheen. And the women out there were very fluent in where they knew the shoe pinched. And it was quite contrary to what a lot of people say. It was not an organized movement, it was a very disorganized movement of about 10, 20, 30, 50 factions. And partly the mediations may have failed because there were so many factions. But whether it be those women at Shaheen, they were at least in an urban environment. Please take the case of young 15, 16-year-old girls in Udupi, who when their bigoted chemistry teacher said, take off that hijab, who said, no, we have a constitutional right. It is not that people do not have an idea that the constitution exists or that the constitution exactly ensures rights. And this right-based conversation traces itself back not only to the constitution but to social movements in this very state. It was a Marathi translation of Thomas Paine's The Rights of Man, which Jyotiba Phule read. And the idea that no man has property in another man, that was a radical idea in its times. And from Phule to Ambedkar to our constitution, it is a continuum. And long after we out here have gone, it will be you who will be living the constitution and who will be fighting the constitutional questions of your day. Professor Daswani said that we live in interesting times. Each time is interesting. Each time will raise constitutional issues. But why do we have a constitution? We have a constitution because it is something like a social compact. This is how we will exercise our citizenship. Our citizenship is the right to have rights. And this is how it will be regulated. This is how we will be ruled. And this is the constitution which has to be protected against transient majorities. There may be great people who will come from time to time. There may be people who may embody the spirit of the times, and the people may love them. But constitutional values will have to outlive the people, the individuals of the moment. And if that message goes to everyone, I think many other problems will be solved. We are a nation which has resolved to live under a democratic constitution. And it is not temporary transient majorities which can just do away with the constitution or tamper with its basic structure. So there was a famous Pakistani poet, Habib Jalib, who once told the dictator of the day, Yahya Khan, वो जो तुझसे पहले यहाँ तक नशीन था, उसको भी अपने खुदा होने का उतना ही यकीन था. So somebody told him, look, ये मौका तो नहीं था ऐसे बोलने का. So he said, मैं मौका परस्त नहीं हूँ. As long as there are enough people who are not looking for an opportunity, the constitution will survive. Thank you.
Collegium is today under attack by various people for various reasons. So it is under attack for various reasons. Now, should we protect the collegium? Should we be in favor of the collegium? I think the answer, what Mr. Hegde has given, is perfect. We must protect our constitution. And the responsibility goes to each one of you out here Because if there is any group of persons in this country who is equipped to protect the Constitution, they are law students. They are people who understand and know the law. Ladies and gentlemen, please take on this mantle. Please take on this mantle to preserve our Constitution, because the Constitution dictates who we are. Thank you.
This was truly a scintillating debate. I'd like to extend my heartfelt gratitude on behalf of Government Law College to all the panelists for engaging with us and enlightening us on ideas and policy issues regarding the collegium and state of judicial independence as it stands today. The debate has highlighted the importance of various aspects of the collegium system, our panelists' views on transparency. We talked about the existing system's limitations in terms of transparency and the judiciary's somewhat obstinate attitude to inculcate more transparent mechanisms into the fold. We learned about aspects of diverse representation or the lack of it in terms of gender and other minority criteria and of diversity.
The scope of discussions extended beyond what we could have imagined and truly emphasized upon the present situation at hand. We are grateful to our panelists for engaging with our audience and providing comprehensive answers to them. Your primary addresses and responses left us in much awe and will continue to inspire us. I would now like to invite our senior core to felicitate all the panelists. Firstly, Senior Advocate Shekhar Naphade, sir.
Anyway, I'm perhaps loud enough. In the ultimate analysis, we must remember it is not the wise man who frames the law, but the one who is in authority.
I call upon another senior board member to felicitate Senior Advocate Sanjay Hegde.
Thank you. I received this as a son-in-law of GLC.
I would now like to invite a senior co-member to please felicitate Senior Advocate Sanjay Ghose, sir.
I'd like to call upon another senior court member to felicitate Mr. Alok Prasanna.
I'd like to call upon a senior court member to now felicitate Dr. Advocate Suresh Mane. Lastly, we'd like to invite our senior court member to also felicitate our moderator for the discussion, Dr. Professor Kishu Daswani. In conjunction with the event, the Debating and Literary Society organizes the Policy Review, a competitive call for articles, opinions, and essays on the theme of the debate, giving an opportunity to students across the country to write about their policy perspectives. This year around, we had widened the topics to 3, including firstly, representation under the collegium system, perpetuating privilege or adequate representation. Secondly, the collegium system as a lesser evil. And lastly, the executive and the judiciary, democratic institutions in conflict.
However, owing to the large number of entries, much more than we had expected, we have prolonged the judgment process in interest of a fair and properly asked verdict. We usually announce the same at the policy debate, but this time around, all the participants will be notified of the results online by the Debating and Literary Society very soon. We thank all the participants for making the policy review grow with every subsequent edition. Keep writing, we encourage more participation, and we are ever grateful for the growth we have seen. Thanks to you all.
I would now like to invite our Deputy Convener, Srishti Srivastava, to please present the vote of thanks.
Good evening, one and all. As we have reached the end of the evening session, it gives me immense pleasure to propose the vote of thanks on behalf of the Debating and Literary Society of the Government Law College. First and foremost, I would like to thank our ever dynamic principal, Dr. Asmita Vaidya ma'am, for encouraging us in all our endeavors. I extend my heartfelt gratitude to our chief guest, Honorable Mrs. Justice Sujata Manohar, for humbly accepting my invitation. I also extend my thanks to all the panelists for flying down from various cities for this discussion. I extend my gratitude to our Professor Kishu Daswani, without whom this event would not have been possible. Our sound I thank the team from Vidhi Center for Legal Policy, Ms. Janali Dani, Ms. Sakshi Pawar, Ms. Shisha Shriyan, and Ms. Isha Prakash. I also thank our media sponsor, SCC and EDC. Lastly, I thank my team, Jona Nagpal and Nidhi Bhasarkar, my junior core members, Ram Gupta, Vikrant Pandey, Dhanashri Dalvi, Reva Varudi, Siddhant Baithankar, Sarthak Das, Himangi Raswan, and Shwet Pandit. A very crucial part of this event was our office staff and our logistical support. Siddhesh Sir, Ajit Kaka, Jadhav Kaka, Anita Ma'am, Shweta Ma'am, Madhvi Deshpande Ma'am, and Mr. Bhushan. We would also like to thank Potion photographers for helping us live stream this event, which will be available on YouTube soon enough. Last but not the least, I thank my audience for being here so late trying to understand the intricacies of the collegium system. I now request you all to please stand for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उज्जल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे भारत माता की जय।